SGL1 Ltd and FSV Freeholders Ltd.
Yes, Mr. White.
May it please you, my lords, my lady, I appear with Mr. Cordova for the appellant, and my learned friend Mr. Asgar appears with Ms. Shakir for the respondent in this matter.
Yes.
My lords, my lady, it's an appeal against the order of Judge Hodge, sitting in the High Court, made on the 30th of January last year.
Yeah, we've read the order, we've read the judgment, we've read the statement arguments.
Right. Would you like me to go straight, would it be convenient if I went straight through into my submissions?
Yes, and I would also tell you we've read Carrot.
Yeah, thank you. Can I take you to the, would it be convenient to start with the notices? I don't need to take you to those either.
Well, I think that might be helpful, thank you.
Yes. My lord, the notices are in the supplemental bundle behind tab 2.
Yes.
At page 120.
Yep.
That's the first notice.
Yeah. The judge recorded that the red edging on the plan went round the built envelope.
Yes.
And didn't include any of the shared areas.
Yes.
That's not apparent from
That
the copies
hasn't come out, I'm afraid, in the bundle before the court.
The ones that we've got.
No.
And nobody seemed to be attaching any significance to that.
No, there isn't any significance. I'm sorry that you don't have the plans that were before the judge, the coloured plans, but there isn't any significance in that point, my lord.
Right.
So the notice is at tab 2, 120.
Yeah.
Following, and if you turn through to 142, that's blocks B, C and E, and the proposed consideration, or the consideration of the proposed disposal there was £1,060,000. It's followed by the plan, which, as you say, isn't marked. And then the next page on 145 is the second notice for block A, which concludes at page 152, and the consideration for the proposed disposal there is £350,000. Pounds. And there are a number of plans, but the one I lighted on as the most convenient for the court is in supplemental bundle tab 10 at 354, which is in the first of the supplemental bundles.
I've got one at 356. 354 is better, is it? 354, which is, yeah.
356 and 356 is perhaps 354 is from a planning application. It shows the blocks with the common facilities. 356, perhaps, as my lord indicates, is perhaps the best plan that we've got. You'll recall that block D has been demolished.
Yeah.
And therefore we're just talking about A, B, C and E in this appeal, as we were at trial.
Oh, block B is demolished, right, okay.
Yes.
D.
D, yes, sorry, D, yes.
D is demolished.
The area is behind a large hoarding, I think, now.
I think that's right, my lady. There are a number of photographs which are also behind tab 10, but in the second supplemental volume, starting at page 467.
So just looking at 354. Block C and block E seem to be shown as one.
They share a common entrance.
Well, it looks from this plan at 354
Yeah.
as though the eastern wall runs through both blocks.
I understand that to be correct, my lord. Yeah. And of course, they with block B, as I'll come on to in a moment, they share common facilities such as one boiler serving the 3
Yeah. So
blocks.
I'm sorry, I missed your last reference.
The reference to the photographs
Yes.
is at the second, it's the same tab but second volume at 467.
I'm sorry, so that's supplemental
Bundle.
bundle
2.
2.
I think it's 469.
I'm
It's the
sorry.
Google.
Sorry, 469. Give me my lady. I've got the page reference.
Sorry, it's not your fault, I was in the wrong bundle. I have them.
If you look at 469, taking up my Lord Justice Lewison's point just now, you can see C and A are conjoined, but at a
C and
lower
E.
level.
C and E.
C and E, yes.
Well, they look separate on page 469.
They do
Well, at the upper level.
at the upper level. As I look at the photo, they look conjoined at the lower level, if I'm right. That would be consistent with the
I
plans we've been
think we
looking at.
may see that at 473.
Yes. Thank you. 470 is a better version of 469. It's blown up.
470.
Yes.
Yeah.
And what seems to be, if you look on 473 and then back and forth to 470, is that the entrance to C and E is in fact at right angles to the building and is in E.
I think that's right, my lady.
It's not as if it's centrally between C and E, it's in E,
Yes.
which suggests then that you must be able to get from there all the way back into C through the building.
I think that's right, my lady.
I mean, that's surmise, but
Yes. There's another photo of C and E at 474, which shows that there are different heights, and that shows the entranceway and the stairwell that my ladyship has just referred to
yes.
more clearly. And 475 is helpful because it shows that block A is a warehouse conversion, whereas the remaining blocks are new builds.
Yeah.
I wanted, unless there's anything else on the photos, I wanted briefly to touch on 2 extracts from the witness evidence that I referred to in my skeleton, if I may. That's both in supplemental volume 1, something.
I mean, is this evidence the judge accepted?
Yeah, it's the evidence the judge summarised. He didn't.
Did
He
he accept
didn't,
it?
in his judgment, reject any specific evidence apart from one aspect of Mr. Ip's evidence. I should indicate that as you've probably picked up, I wasn't trial counsel, but I'm obviously familiar with the judge, very familiar with the judgment. But this was certainly evidence the judge didn't reject. If you look at the judgment, he summarises the evidence and then goes on to his analysis without saying that he rejects anything. And the bits I'm referring to are, I would hope, Mr. Ascot will tell me if I'm wrong, but I would hope my lord, non-controversial.
Right.
I hope, forgive me for a slightly long-winded response to your lordship's point, but I hope that answers the point. At tab 7, 267, there's the witness statement of Mr. Howard, and he says at paragraph 7, all services installed were to accommodate all 3 blocks. That's on 268. I'm on 268 now. There was 1 boiler installed to service all 3 blocks. He's referring to C&E. 1 CCP system, generators, substations, and service tanks to service all blocks. Blocks were painted the same colour and had the same features fitted. Structurally and aesthetically, there's nothing to differentiate blocks B, C, and E. But I make that point to suggest that if you try and sever blocks B, C, and E, you have a problem because you have 1 boiler in particular servicing all of them. And then if you turn back a tab to tab 7, witness statement of Mr. Howard.
That's where we were.
Sorry,
Mr. Howard.
sorry. Turn forward one to Mr. Moore at tab 8.
trouble with Mr. Moore is he wasn't there at the time.
No, he wasn't. But he's commenting and describing on the blocks, but he just makes the same point of paragraph 6 on 273, saying that they were serviced by one plant room, which is contained in block C. And these are real statements of uncontroversial facts, I hope. Could I take you next, having looked briefly at the facts, to the Act, which is behind the first tab in our joint authorities bundle. And just picking up on section 1, section 1(1)(a), a landlord shall not make aware of the disposal affecting any premises to which at the time of its disposal part applies. He has, unless little a, he has, in accordance with section 5, previously served notice under that section with respect to the disposal on the qualifying tenants of flats containing those premises, and the disposal is made in accordance with the requirements of section 6 to 10.
So the operative word in section 1, subsection 1 is premises.
Premises, exactly. But subsection 2(a) does, this part applies to premises if they consist of the whole or part of a building. So building comes in for the first time there, but unhappily, as we know, and which is the reason why we're here, it's not a defined term in the Act. Turning on to the material section that's before us, section 5, which we find at page 11 in the authorities bundle.
It is helpful to look at 3.2 whilst we're on our way, and 2, at 2.1, both use the phrase premises consisting of the whole or part of a building, both in the context of for the purpose of this part, the landlord must do various things in 2 and qualifying tenants in 3, but it's particular premises consisting of the whole or part of a building.
My lady, forgive me, yes. Thank
Sorry,
you.
and then you're at 4.
But I skipped through to 5,
5.
the offer notice, and the question, of course, before you is whether the offer notice is a valid notice. It refers to the offer notice at 5.1, and then the critical section for our purposes today is 5.3 on page 12, where a landlord proposes to effect a transaction involving the disposal of an estate or interest in more than one building, whether or not involving the same estate or interest, he shall, for the purpose of complying with this section, sever the transaction so as to deal with each building separately. And that was the section that the Deputy Judge, Mr. Foss, as he then was, had to grapple with in CAG. It's important to look at section 10(a), just to note the point that the failure to comply, and 10(a) is on page 25, failure to comply with the requirements of section 5 is an offence.
And this was inserted in 1996 or so.
It was, yes, if you look at note F47, it was inserted in 1996, so it was inserted before Carrot, and I think was referred to by the Deputy Judge in Carrot.
Yeah.
And one of my submissions is to the effect that if you're going to make it's an offence not to comply with something, it's got to be as straightforward as possible, because of the risk of creating a person committing a criminal offence inadvertently.
Presumption against doubtful penalisation.
Thank you. No, putting it succinctly.
Well, that's what Benyon calls it.
Yes, yeah. Well, I'll gratefully adopt that. And the more factors that one brings into play, as the judge did, and I'm not particularly criticising the judge for doing, because he was following the law as it was and is before consideration by the court. But the more factors one brings into play, the greater the risk of falling foul of Section 10A. The last section I want to take you to is right at the end of tab 1. It's the general interpretation section. I've identified this in my skeleton, and I've referred to the definition of common parts and dwelling. And common parts means structure and exterior of that building or part of it.
Beg your pardon, could you give me the page again?
43, my lord.
Thank you.
Common parts relates to a building or part of a building, includes the structure, exterior of that building or part and any common facilities within it. Now, what I say about that is that it does rather suggest that a building is a singular building is the same thing as a structure. It's difficult to read that and come to the conclusion that a building can be more than one structure, a building equals building or buildings. And if one looks at dwelling, dwelling means a building or part of a building occupied or intended to be occupied as a separate dwelling, together with any yard, garden, outhouses and appurtenances belonging to it or usually adjoined.
The word dwelling wasn't used in any of the operative provisions we looked at earlier.
It wasn't, no. But if one's trying to discern the intention of Parliament when Parliament hasn't said what a building is in this Act, there is I would respectfully submit, my lord, a suggestion in the definition of dwelling that the draftsman had in mind a building being a single structure as opposed to more than one structure. It's not the best or most important point, but it points us in the right direction, I would suggest.
Dwelling is used in the part of the Act that deals with variation of leases, I think. It's not used in part 1 of the Act at all.
No.
At least I couldn't find a reference to it anywhere.
I think that's right. But yes, I accept that's right. Yeah. I was going to go next to carrot. Of course, I'm aware that the court would have read carrot carefully. Would it be helpful for me to go through the ratio of carrot, or
Yeah,
shall I skip over that and go straight to the judges?
No, you can.
No.
You're arguing that carrot is wrong.
I am.
Well, I think you better take us to it then.
Yes.
And tell us why it's wrong.
Well, I've already hinted why I suggest it's wrong, because my suggestion is that building can only mean one particular structure with a proviso that I'll come on to later. But carrot attempts to solve a problem and goes, in my submission, too far in solving that problem. And the problem of the fact the building isn't identified, defined in the Act, and it isn't clear. The problem that the deputy judge faced there was a similar problem to the problem that Judge Hodge faces in this, or faced in this case. That the Act doesn't really focus in on a situation where you have, as an estate of multiple blocks and pertinent premises. Carrot was a residential estate with 4 structures and 55 flats. Here we have 3 or 4 or 5, depending how one interprets it, 2 or 3 or 4, or even 5 structures similarly. The judge, the discussion at 65 starts with the question of whether that can be a building can be a building scheme on the basis that a scheme can mean a single development of one or more buildings built at the same time. And the judge rejects that. At 66, he says the legislature must have be taken to intended to create a workable procedure. At 68, he says the Section 3 was intended to prevent landlords amalgamating separate structures or buildings into the same transaction so as to hinder
Sorry,
qualified
which
tenants.
paragraph are you on?
68, my lord. It's one of the ones which we've sidelined.
Yes.
In achieving the necessary I'll start again. It was intended to prevent landlords amalgamating separate structures or buildings into the same transaction so as to hinder qualifying tenants in achieving the necessary majority to enable them to purchase the freehold. It was not, however, intended to require integrated developments to be split into inappropriate and unwieldy sections. That's a sentence that I do take issue with, and I invite the court to disapprove when considering and coming to its judgment. Inappropriate and unwieldy sections is a very subjective comment, and it's inconsistent with the normal understanding of the word building, which just means a singular building or a structure. So that's one issue I have with Carrot. At 71, the Deputy Judge goes on and says this: in my judgment, however, the term building as used in the Act must have been intended by Parliament to include more than one structure in some, albeit limited circumstances. The question arises as to what precise circumstances. For example, one could imagine that two structures with a shared access might sensibly be regarded as one building for the purpose of the Act. That, of course, if that is correct analysis, would in our case make C&E one building. There's nothing in the legislation, however, which gives any hint that might have been the intention of Parliament, just as there is no hint that building schemes were intended to be regarded as a single building because they were constructed at the same time. So the Deputy Judge dismisses the building scheme idea. At 72, he identifies that there are a few clues in the legislation as to how the absurdity involved in construing Section 5.3 as referring strictly to a single structure can be avoided. Again, I submit it's not absurd, it's the only natural and logical explanation to refer building should be referred to a single structure. For example, there's nothing in the Act which explains how difficulties associated with severing a transaction can be resolved. Well, there may be nothing in the Act, but it's perfectly possible for leaseholders to have rights or easements over adjoining properties, I would suggest. It's the absence of this provision which led me to think...
Sorry, where are you?
I'm on 72, my lady.
Yeah, thank you. I thought you were.
The top of 70. I'm on the third sentence down, third line down. It's the absence of this provision which has led me to think that Parliament must have intended the Act to be construed so that such provision was unnecessary. It would only have been unnecessary if qualifying facts containing structures which have been used in the same associated or pertinent area in common, which are regarded as one building for the purpose of a severed transaction. This is the single intractable problem identified by Longacre. In this case, it says with some force that it would be impossible to satisfactorily divide up the use of yards, roadways and gardens that have been used in common by the occupiers of all qualifying flats in the estate. Now, the difficulty here is you'll recall that there was no contrary submissions, and therefore the judge didn't have the benefit of submissions on the part of the tenant, but the tenant could have said that actually it's not impossible to divide up use of the yards or to grant one block right over yards which are within the demise of the other yards, and so forth, roadways and gardens. That would be a contrary point which wasn't put before the judge.
Well, normally leaseholders, if they've got rights over shared facilities, those rights will continue to be enforceable against new landlord.
Exactly.
But what do you do if you've got an estate-wide service charge with each tenant, each leaseholder paying a proportion referable to the number of flats in the whole scheme? How do you split that up?
Difficult. It's difficult to split that up.
I mean, if you've got a management company doing it, I can see that the management company just carries on doing it, collecting the service charge from all the lessees of the whole development. But if as here, it's the landlord who collects the service charge.
The only solution to that problem, which I recognise and accept is one of the problems faced by this that this section throws up is that you have to just simply reconstitute the service charge for each block once you've severed the transaction. I mean, you have to produce a workable solution. I mean, that's
So what do? You, at the time when this Act was passed, it did include provisions for varying leases, but in fairly limited terms. There was the possibility of some sort of an apportionment under the Law Property Act. There is now a mechanism for apportionment under the Landlord and Tenant Covenants Act, but that didn't exist at the time this Act was passed.
You would have to vary the leases, my lord.
You would have to.
You'd have to vary the leases. I think that's the only solution. I mean, the tension here is between deciding that because it's practically difficult, the building has to mean more than one building, and moving away from the logical definition for building. The tension is there between there and then on the other hand deciding that a building has to be more than one building because severing the transaction creates problems.
And paragraph 72 in the judge's solution in Carrot doesn't solve that problem for what he called a building scheme.
No, it doesn't. My Lord, 74 I was going to go on to, and this is really the ratio of the case. The Act can only make sense if the word building is construed to mean, I accept somewhat awkwardly, either a single building or one or more building where the occupants of the qualifying flats in each of the buildings share the use of the same pertinent premises. And he says, I've used the term pertinent premises as used in section 4.4 in the Act for simplicity. If this is correct construction of the Act, then it's true that many building schemes, as Long Acre has called them, will fall within the definition I've intended. But in my view, although there's some statutory warrant for my approach, there's none in the suggestion of an earlier case, Upton Gardens. I think that was a leasehold valuation, the Lands Tribunal case, that the word building should be construed in formal ways to include all building schemes. So the judge was very focused, the deputy judge was very focused on the dichotomy between a building and a building scheme, and just came to the conclusion that the only logical thing was that the word building had to be divorced from the word structure. And I respectfully submit this is where this particularly learned judge fell into error, and that the correct approach is that a building must mean a single structure, with the proviso that if two structures are in practice indivisible, they are to be treated as one building. So you have, in this case, that has to be, I accept, a limited proviso. So I'm not moving terribly far away from carriage.
So what's your proviso?
My proviso that if the two structures are in practice indivisible, then they are to be treated as one building. So the two examples I give on the facts of this particular case are C and E have to be one building because they share a common entrance. It can't be contemplated that you divide the structure and create a separate new entrance. That just can't be, that's a nonsense. But I also say that B, C and E are one building because they share the one boiler and common facilities as indicated in the short extract from the evidence I showed you. That's my route through to seeking to persuade the court that B, C and E are one building.
So the test is a building should be a single structure. That's where you start.
Yeah.
The proviso being that, and you said if in practice it's indivisible from other structures, then they are all one building.
My lady, yes.
And so, what are the factors about the indivisibility? You've said here you've got one entrance, and you've also said one boiler. So we're talking, are we? I'm just trying to think in the abstract about your proviso. So, excuse me, so it is it shared facilities? How wide is that Is that too wide a term?
Shared facilities would be too wide a term. For example, the judge in this case identified one of the relevant factors in concluding there was one building as a shared car park, where, for example, residents of one block had a right to park in a parking area associated with the other block. That would be the wrong side of my hypothetical line.
Okay, I'm trying to find where the line is.
Yes, it's one has to test it. I accept, my lady, by practical questions such as the question that your ladyship has asked me. But what I have in mind is the question of a physical, when a physical division of facilities makes separation impossible. Therefore, you can't fairly obviously create a new entrance without a lot of work. And if a boiler is shared, then that has to be shared, and you can't create a new boiler without a lot of work. So, whereas something like car parking,
but why not? Why can you not create a right to receive heat from the boiler?
well, I suppose that would be theoretically possible, my lord. But it's once you go in that direction, it becomes more complicated, and it's really important, I suggest, to only use not to use shared facilities where there's a degree of complication there. So if as here B, C, and E effectively share a lot of common facilities, the logical thing is to treat them as one building rather than divide those up. It's
difficult
close
to
to
see
character,
what
the
kind
shade
of
on the
right it would be.
It's
It's not easy to see what kind of right it would be. You can't have an easement to receive hot water or heating. You can have a right to receive water, but if the servient owner has to do something, it stops being an easement, as far as I can recall.
Well, your lordship's come up with a better answer than I have to that point. But
You can have contractual right.
yes,
Have a sort.
So you're saying, I'm just thinking about, I'd like to know what you say about appurtenances in a moment, but if, for example, away from, specifically from this case, but if the flats, or whatever they were, studios in C and B, which are on either side of a parking area and an access way, also in that space had a shared garden, which, and in some of the planning plans, of course, we've got bushes and things, but it doesn't seem from the photos that they're there. But if there were a shared garden space between C and B, and the leases of in B and C said, and right to use the garden on both sides, would that be that's appurtenant perhaps, but tell me about that. And then does that mean, is that a factor which shows that the blocks on either side of the accessway are in fact one building?
I'd have to answer no to that, even though that might be contrary to the conclusion I'm just trying to persuade you on the facts of this case, which I'll come on to in a minute, because it seems, I'd suggest that easements could easily be created in favour of leaseholders in one block over leaseholders in another block to use a garden. So in terms of my hypothetical proviso, that would fall on the other side of the line, my lord.
So you're proposing that actually this severance in 5.3
Yeah.
into so that your transaction only relates to a building actually creates more onward repercussions, because then you have to very leases create new rights, etc.
It does create some repercussions, but the only alternative is to take the word building away from its natural meaning. If the repercussions have to fall where they lay, if one comes to the conclusion that because there are repercussions, building can't mean building, that is a more profoundly unsatisfactory conclusion than dealing with the repercussions, I would submit.
Does it depend on the extent of the demise?
Yes, it may do. It may depend on the extent of the demise.
I mean, take a car park. If the car park forms part of the demise, as opposed to it merely being an easement to use a shared car park, does that make a difference?
That could make a difference, my lord. Yes, if it was part of the demise, because
But I think when our sample leases, the one we've got for block A does include car space.
from recollection, no, it doesn't. I mean, it was.
No. Thought it did.
Sorry, forgive me, my lord. I may not have heard you correctly.
I thought in the sample lease that we've got for block A, there was a car space included in the demise.
Yes, sorry, I didn't hear you properly. Yes, though it was commonly found at the trial below. I understand that the leases weren't the greatest of leases drafted, but yes, I think that it does include.
Trying to understand the service charge is very difficult, since building and estate share the same definition.
Yes.
Can I just explore the gardens hypothesis?
Yes, my lord.
We're hypothesising two blocks, I'll just call them word for the moment, with a garden in between them. Does the hypothesis include any easements for the tenants to use the gardens?
Yes, it does.
So if the blocks are separated, those easements will remain in place.
They will.
And if there are no easements, then what right do the tenants have to have the gardens anyway?
Exactly.
So as I understand it on your submission, things like shared gardens aren't a problem. Whereas I think you're accepting that a car park that forms part of the demise is less easy.
Yes. It's not an easy line to draw. I accept that, but I think my overall submission is that the line in Carrot and the line that the judge drew below, where he adopted some suggestions made by Radesky and Clark in their useful book on the subject, and then extended those to include other factors, was drawn really too widely. And that which led
your focus is on the structure.
Yes, my focus is on the structure. That should be the starting, the end point, and one can hypothesise, I accept, a number of problems saying that the building.
By structure, we're in danger of getting away from what we're actually talking about.
Yeah.
By structure, as I understand it, you mean a functionally integrated built envelope.
Thank you, yes.
Sorry, do you repeat that? Structure is
A functionally integrated built envelope, I think my lord said.
And so you'd say that was perhaps C and D.
C and E, but I'm
You include B because you say it's functionally integrated because of the shared plant.
exactly. Yeah.
So you say the fact that they've got distinct walls and distinct access is not sufficient.
It does. It keeps it on the building side of the line as opposed to the buildings side of the line. That's what I say about the difference between B, C, and E. If that is right, then I mean, which is clearly the conclusion, the draftsman of the notices that I showed you earlier came to. This list who drafted from Hildings and drafted the notice, that was the conclusion she came to. But
What do you do with widely separated blocks sharing a common district heating system?
they have to, on my analysis, they have to, if they have to be a building. If they're sharing those facilities, they have to be one building. They have to fall within my proviso.
And what, if anything, does this have to do with appurtenant premises? I'm just going back to my garden.
Yes, yes, of course. Sorry, could your ladyship answer?
Well, how does appurtenant premises fit into this analysis, if it does, or is it irrelevant?
I'm respectfully not sure this is relevant.
Okay.
Yeah. Which is why I skipped over the paragraph in Carrot where the judge commented on it.
Because a lot of Carrot is based perhaps on appurtenant premises,
Yeah.
and there are other authorities which are based on that.
Mm.
And we find that definition in section 4.4
Yes.
and used in 4.41.
My lady, my lords, that was what I proposed to say about Carrot, and you have the submission that they made before I move on, which was to look at the judgment where the judge focused in on Carrot.
Yeah.
You may have further questions on that, or the court can of course come back to me later on questions that arise, but I was going to move on to the judgment
Right.
next. Which we're back to the core bundle now. And the judgment is behind tab 9. And if I start at 28, the judge expresses his concerns, which is no doubt what led him to grant permission below, about the correctness of the decision in Carrot at 28. He refers at 29 to the fact that it's in mandatory terms. He refers at paragraph 30 to the fact that section 10 makes it a criminal offence. But then he concludes correctly, of course, that it has stood for 20 years and it wasn't appropriate thing at 32 to revisit the correctness in that case. So he then endeavoured to follow Carrot. What he did, just coming back to a question that my Lord Justice Lewison raised with me as an early point in my submissions about whether the evidence was accepted, from 34 onwards, he simply summarises the evidence. Yeah. He doesn't reject any specific element of the evidence, except that very irrelevant point that Mr. Mick made when Mr. purported to give expert evidence. He moves on to submissions, which I will skip over. And he moves on to his analysis at the bottom of at the very bottom of 93. At 72, he emphasises the particular importance of common access through the highway at Back Bow Street, which runs between blocks A and E. That was of particular significance to the judge. I would respectfully suggest he gave that a bit too much weight. Again, comment on the leases.
And just pausing on that, as my Lord Justice Arnold put to you, demise might make a difference, and he says at the end of 72 there are leaseholders at Block A whose demise extends to individual surface car parking spaces outside blocks C and E and possibly Block B also.
Yes. So that clarifies that particular point which my Lord raised with me about Lord Justice Arnold.
Yeah.
So I accept that there's a demise of car parking spaces outside other blocks, but that doesn't follow from that the blocks have to be all the same building. In my submission, the building can extend, you can still have demise of a parking space in a different block without making that block, incorporating that block into your building. That's what I would say about that, if that's the question.
Well, in one sense, you could say it doesn't matter because the demises are still distinct, obviously, and the fact that the demise from Block A extends to spaces outside Block C, you could say it doesn't matter. But on the other hand, it creates a bit of tension. I think you accept it with the idea that it's purely about structure.
Yes, it does.
Well, I think, if I remember rightly, wasn't one of the points either Dean Tower or K Green, there was a garage block, and some of the tenants had leases of the garages and some of them didn't, and it wasn't part of the same building.
That's
One of those cases. Was it Dean Tower?
I think it was Dean Tower, and yes, that was the conclusion that the court reached on that case. They weren't part of the pertinent premises.
And I suppose you would say
But they
it doesn't really matter whether the lease of the unit and the car space are in one document or in two. The legal effect is the same.
Yeah, they were separate leases in that case. Yeah. At 75, the judge observed he obviously had better plans than we have. The red edging shown on the plans extends to the exteriors of the blocks themselves. It doesn't extend into the common areas. Then, if we move on to 79, he identifies the factors that are relevant, referring to Radetsky and Clark factors. Plans of the structure and underlying structural support of the structures, lessee's right to use the pertinent premises, connections at zone level, dates of construction of the structures, how the structures are managed, how the service charges operate, and visual impressions. And he identifies at paragraph 80 5 other means of access, how the structures are serviced, sharing of common facilities and amenities, planning history and requirements of housing legislation, and measures considered necessary to enforce compliance with them.
And what do you say about all of those? Do they all go out with the bathwater being carrot, or are they relevant to where we are on your test?
I say that they go out with the bathwater, my lady.
Mm-hmm.
The problem, one can see why the Radetzky and Clark have come to the conclusion, and one can see why the judge felt constrained to identify factors, but the difficulty with this is the level of, as evidenced by the argument and the dialogue that has been between counsel and the court this morning. The more one gets into these different factors, the more problematic it becomes. The more, if you imagine the difficulty a draft person has in writing a Section 5 notice at the moment and drawing a plan, how do they know what's...
So you say an important consideration is it should be a clear and practical test.
Yes, my lord, yes, I do very much so.
The list in paragraph 2.9 of Radetzky and Clark, which is what the judge was referring to at 79,
Yes,
is formulated on the basis that Carrot is correct.
yes,
Now, if you say Carrot's wrong,
yes,
then the list goes out of the window.
yes. That's what I
Sounds
answer.
like that.
It's an attempt by the authors to rationalise Carrot. That's the submissions really on the first ground of appeal, but I've really shaded into my submissions on the second ground of appeal, which my Lord Justice Lewison gave me permission for last year, which is the more factual ground that B, C, E and E, B, C and E are one block and A is another block, and therefore the judge got the facts wrong.
Well, is it so much that he got the facts wrong? I mean, what he says, I think, somewhere or other, he says that the magnetic factor for him is the parking.
Yes.
Can't find the use of that word. but
Paragraph 83.
Thank you.
It's
Yes.
the shared use of Back Bow Street as the only means of access to the car parking spaces.
Yeah.
Yes.
So that's what drives his decision.
Yes.
And if, as you say, if you are right in saying that Carrot is wrong, then he's approached his evaluation on an incorrect legal premise.
Yes.
But then you were going on to say, I think, that even if we don't accept your primary ground, which is Carrot is wrong, even on the assumption that Carrot is correct, you still say the judge reached the wrong conclusion.
That's my ground 4, for which
You've got permission, but it's more tricky.
it's a more tricky one because I'm attacking fact finding by a judge who heard the evidence I accept. But effectively, if my Lord Justice Lewison has identified the magnetic attraction paragraph, this is quite a surprising conclusion by the judge that shared access through a highway could make.
Sorry, you said through a highway?
Well,
Is it a highway?
Back Bow Street.
Is that a highway?
I believe so.
Right. I did notice that when Mr. Voss was talking about shared access, he didn't differentiate between private access and highway access.
No, but that's quite an important distinction. I think I'm right. Mr. Ascot will correct me if I'm wrong, having been there below. But I'm pretty sure that Back Bow Street was a highway and not part of the estate.
Is that something you can shed any light on, Mr. Ascot?
I believe that's to be correct.
It's a highway.
Yes.
Thank you. So the judge goes really too far in bringing these what I would say are extraneous factors into his conclusion to reach the conclusion that A, B, C and E are all one building. A particularly surprising conclusion when, of course, you recall that A is a warehouse conversion and B, C, E, and relatively new build blocks.
Yeah.
Probably not a lot of something more I can say about that because I've effectively made that submission as I've been going along.
So in relation to this, on the basis that Carrot is correct,
Yeah.
you're saying nevertheless the judge took into account a factor he shouldn't have done, or reached a conclusion
Took into account a factor he shouldn't have done.
which is the back bow street.
Back Bow Street, yes. That is. My Lord, my Lady, in essence, those are my submissions.
Thank you very much. Mrs. Hall-over, do you want to add anything?
My Lord, I'm grateful. No, nothing to add.
Right. Yes, Mr. Ascot.
May it please my lords and my lady, if I may, I intend to approach my submissions in the following manner. First, I shall analyse the decision in Carrot with reference to four main factors. One, the commentaries which have criticised the decision and which has resulted in us being here today, in effect. Two, the presumption against absurdity. Three, the aims of the 1987 Act. And last, other cases which might be of assistance in construing the Act. I'll then move on to the second strand of my submissions, which is addressing briefly the judgment below. And then third, I shall address the respondent's notice.
Yes.
Turning to the decision in Carrot. And if I can take the court to page 239 of the authorities bundle.
Just hang on a bit.
But you were going to page 239?
Of the authorities bundle.
Okay.
239.
That's correct.
This is the Butterworth's property services. Or
Yes,
just
this is
Rudetsky and Clark.
Rudetsky and Clark, yes.
Is Rudetsky and Clark.
So at the bottom of the page, the last sentence, we have a hypothetical scenario, which is, by way of example, consider an estate consisting of two blocks, one containing 10 flats and the other 12. If all of the tenants in the smaller block wish to exercise the right of first refusal, they would be unable to do so if none of the tenants in the other blocks chose to. And the footnotes over the page, first footnote, basically says,
We're looking at footnote 4, are we?
footnote, my apologies, it's not the footnotes, I'm looking at the assumptions by the judge and why they call into
Yes,
question.
that seems to be part of footnote 4.
Yes, yes. So that the first one is, it would appear that by amalgamating blocks, one is doing exactly what the Act intended to stop. And that's a fair question. And in my submission, it's this commentary which has resulted in the so-called controversy around the decision and which Judge Hodge had in mind. But if we look at the example given by Radevsky here, in this case, treating the 4 blocks as one building, in fact, assists the tenants. As I've set out in more detail at paragraph 42 of my skeleton, Block A was valued at £395,000. Blocks B, C, and E were valued at nil. And in those circumstances, the respective tenants were unwilling and potentially unable to purchase each building individually. The development in my submission is too interconnected for anybody to purchase it one by one. But as soon as the
So what has the valuation got to do with it? Isn't your right to buy on the same terms that the landlord is proposing to sell?
that's correct, but I'm dealing with the problem identified by Radevsky, and that what happens when you amalgamate separate buildings together. And in this case, when the four buildings were treated as one, when the tenants learned that the property had been sold on that basis, they immediately offered to purchase it at 1.65 million for the entire block. Whereas when it was individual, they didn't even bother to put forward an offer. So my submission, and I'm going to amplify this, is there might be some cases where amalgamating the blocks together assist the tenants, and there may be other cases, such as the K Green case, where doing so would work against the tenants. And it's against this backdrop that the court will be aware, as set out in Carrot and various other cases, the 1987 Act has been described as ill-drafted and confused. And some authors even suggested that's an understatement. What the Act does not do, it doesn't deal with how integrated developments are to be separated, nor does it provide a definition of a building. What that means, whichever construction of the Act is ultimately preferred by this court, there is no interpretation that will satisfy all tenants and all landlords in every single conceivable scenario. The difficulty before this court is that any principled interpretation will inevitably advantage some parties and disappoint others. It's impossible to frame a construction that will please everyone. As the famous saying goes, you can please some of the people all of the time. You can please all of the people some of the time, but you can't please all of the people all of the time. And that's exactly what we're faced with here. And what the decision in Carrot, however, does was adopt the interpretation that is most consistent with the statutory purpose, and in particular, one which does not produce absurd or unworkable outcomes. And the keystone of my submission is going to be, as set out by Sir Geoffrey Voss at paragraph 68 in Carrot, that Parliament did not intend integrated developments to be split into inappropriate and unwieldy parts. With that in mind, if I can take my lords and my lady over the page to 243, this is Bennion on statutory interpretation. The presumption against absurdity is well known, however, it can be quite nuanced. And as the author set out here, the court will seek to avoid a construction that produces an absurd result, since it's unlikely that's what Parliament intended. The courts give a very wide meaning to the concept of absurdity, using it to include virtually any result which is impossible, unworkable, or impractical. Inconvenient, anomalous, or illogical, futile, or pointless. Artificial or productive of a disproportionate counter mischief. And I add emphasis to the word counter mischief, for reasons which I'll expound on shortly. And the strength of the presumption, as the author set out, depends on the degree to which the particular construction produces an unreasonable result. And at the bottom of the page, in the penultimate paragraph, the authors clarify, the more unreasonable the result, the less likely it is that the legislator intended it, and accordingly clearer the wording is needed.
Sorry, where are you?
The
Oh, I see,
penultimate
the
paragraph.
rules bottom, yeah.
Yes. The clearer the wording needed to produce that result. in pausing there, in my respectful submission, if block A were to be treated separately from blocks B, C, and E, that would require the development to be split into unwieldy parts. And for reasons which I'll amplify, that produces a highly unreasonable result. If that's what Parliament intended, clear wording would have been needed, which is not present in the Act. I'll accept there's a clear tension in the Act for the point which I've just raised, in that it might be said that amalgamating separate structures is exactly what Section 5.3 was intended to prevent. And as I'll explain in shortly, Sir Geoffrey Voss was live to this tension in his judgment.
Is it your argument that any split of these, I'll call them shared facilities, would necessarily be impractical and unwieldy?
It's a matter of fact and degree. Each case will fall in its own facts. In this particular case, I submit that certainly is the result. In other cases, it would depend on different circumstances. In the Denny Tower case, I believe, and I'll come on to, the court found that the appurtenances should go with the buildings. And some of the other cases, which I'm going to address, the courts basically said it doesn't matter, you can separate them out. So it is a matter of fact and degree, it's fact specific. But importantly, in this case, I submit it would produce that result.
So it's not your argument that where structures share common facilities, it necessarily follows they are a single building?
Not always, it depends what those facilities are. If it's something small which can easily be partitioned off or rights away easily managed, perhaps not. But where we're dealing with an integrated development, and let's not forget, these flats were intended to be a student village with students passing freely back and forth as one would expect. So in this particular development, it simply isn't possible, and nor would Parliament have intended it should be split up.
Does the judge make such a finding?
He doesn't either way, no. So there was no express finding that it's impossible to split up the car park and the other shared spaces. And likewise, he made no express finding whether it's possible to split the plant and divide that between the respective blocks. It goes both ways.
The reason I ask is that at this stage in the procedure under the Act, it's for the landlord to decide what he puts in his offer notice. And so there may be cases where the landlord can decide, I will allocate the car park to such and such a block and the garden that my lady was talking about to another block. And if the lessees have rights over the car park and or the garden, so be it.
In my submission, a landlord can't do that. If a landlord cannot do that,
Why not?
If and I'll refer to them, the appurtenances are shared between various blocks, my submission is going to be that they need to be treated as one. I would submit it's common ground between the parties that the court needs to depart from the express wording of Section 5.3, whichever outcome is preferred. The real question is to what extent and how. in my submission, if in drafting Section 5, Parliament intended that separate structures with shared appurtenances amounted to one building, then the decision in Carrot does not defy the purpose of the Act nor the operation of Section 5.
How do we ascertain the purpose of Section 5 and in particular 5.3? And Deputy Judge Voss, as he then was, seems to have taken a view on what the statutory purpose is, but it's not entirely clear to me, reading his judgment, where he gets that from. Is it purely his interpretation of the language of the legislation, or was he relying upon extra statutory materials for his ascertained purpose?
My Lord, if I may, I'll answer that in two strands. Firstly, to ascertain the purpose of Section 5.3, the starting point has to be the introductory text and the overreaching aims of the Act, which must be the guiding principle. Coming to the specific intention of Section 5.3, I understand it's not in the case. I understand there were a lot of examples in that period of landlords deliberately amalgamating structures into one building to defy qualifying tenants the requisite majority that they needed. But I say that anecdotally. I don't have any authority or to that, anything to that effect to mind. But I have come across commentaries which I can't cite right now, but I have come across some commentaries which refer to those examples. My Lords, I submit His Honour Judge Hodge was quite right to point out that Carrot was undefended, and therefore it needed to be taken with some caution. However, in my submission, and I'll demonstrate, Sir Geoffrey Voss fully and properly considered all the relevant and competing statutory provisions in detail, the tension between them, how the amendments were enacted, and reached the correct decision which this court should uphold. The decision itself contains a very helpful summary of the relevant legislation and case law, and for the most part, unless the court requires, for convenience, I shall refer to the relevant provisions by reference to the judgment rather than the primary instruments or the law reports. So with that in mind, if I can take the court to paragraph 31 of Carrot, which is on page
Page 60.
60, yes. We're going to spend quite some time dealing with the reasoning and the thought process in the judgment, because it's demonstrative of the end result. So here at paragraph 31, noting that the Act was poorly drafted, the Deputy Judge, as he was then, considers the guiding principle in my submission at paragraph 32. And to amplify on the answer to my Lord's question before, as the long title provides, the Act is an act to confer on tenants of flats rights with respect to the acquisition by them of their landlord's reversion. And in undertaking this difficult exercise before this court, this must be the guiding principle. If I can then move on to paragraph 37 over the page. Here we have section 5.3 of the Act as it now appears. And importantly, this was inserted by Schedule 6 of the Housing Act 1996. And I would ask the court to bear that date in mind, because for reasons I'll expand on shortly, the history of the amendment suggests that in enacting this provision, Parliament was aware and intended that the term building, as it initially appeared in Section 1 of the Act, did include appurtenances.
What did it read before? Do you know?
Yes, I checked it out. There was no Section 5.3 was not there. There was no requirement to.
Section 3 is as it was originally, and 5.3 is as it was originally enacted, is it?
Yes.
Sorry, I thought you said the opposite. Section 5.3, as it now is, was that in the same or similar form before?
It was inserted for the first time in 1996. Prior to that, it did not appear. There was
That's
no.
what I thought you
Yes.
said.
The amendments were necessary because of the introduction of sections 5A, 5C, 5B, 5D, and all that.
Yes.
Because before those amendments, there was just an offer notice.
Yes, and there was no requirement
So
to.
section 5 had to be amended to take account of the different types of offer notice. But 5.3 stayed as it was. Is that right?
5.3 was not there prior to 1996.
It wasn't there at all.
No, the original Act, as it was enacted, it contained no requirement to sever a transaction. I shall expand on that point in some detail as I go through the judgment. However, for the time being, can we go to paragraph 42, please? Here, Sir Geoffrey Voss clearly had in mind the criminal offence which was committed, and it's important to note the offence is only committed if, without reasonable excuse, a landlord makes a relevant disposal. And I would accept it's quite right that given a breach of Section 5 is a criminal offence, landlords should have clarity to ensure they know exactly what they must or must not do. And ideally, a better drafted Act would achieve that. But the Act is what it is. It does provide a safeguard of the wording reasonable excuse. And although categories of reasonable excuse are not closed, in my submission, if a landlord, acting in good faith and on expert legal advice, undertakes a particular course of action, as the administrators did here, if that turns out to be wrong, then that would amount to a reasonable excuse. However, regardless of the sanction for non-compliance, the interpretation of the term building in Section 5 is an objective and antecedent exercise that, one, must be undertaken independently of Section 10, two, must be undertaken with the aims of the Act in mind, and three, must be undertaken without creating a counter mischief or absurd results. And that is exactly what the Master of the Rolls did. And in fact, at paragraph 100 of his judgment, Zaccaroli J. in York House case.
Just hang on a minute. Going to York House.
That's at page 176 of the bundle. Looking at tab F.
Paragraph 100.
Yes. So it's the exact same point was made in this case, that since a criminal sanction is imposed for non-compliance, the provisions of the act should be construed in that context. And what the court says here is the task of the court is to construe the provisions of the act in light of their purpose. Whereas I have found the purposive approach leads to the clear conclusion as to the definition of the premises to which the act applies, then I do not think that the conclusion is to be shaken by reason of the fact in another case and a different context there might be a criminal sanction imposed. So whilst the criminal sanction is an important factor in the court's judgment, the interpretation of section 5 must come first and independently of the sanction. Turning back to the decision in Carrot at page 65, if I may. And I'm looking at paragraph 50. Here, Longacre contended it would be horrendously complex and unworkable to serve separate notices in respect of each of the 4 structures and to divide up the gardens and roadways and provide appropriate rights of way and drainage rights and the like. In my submission, we have a very similar scenario here. Although splitting up of appurtenances, whatever they may be, and or other parts of the building, such as the plant room, car park, and so on, even though it may theoretically be possible, the issue is it in practice, is it workable? Would doing that create greater mischief than simply treating the buildings as one? And there's a plethora of issues which can arise. I'll summarize and rely on 4, if I may. One would be dealing with the service charges. How would that happen in practice? The difficulties associated with that. If that required leases to be varied, how would that process happen? Who would decide the leases to be varied? What variations would take place? What if there was disputes, which inevitably there would be, over the variation? We're simply looking at further satellite litigation and issues.
Well, that Carrot doesn't solve that problem, does it? Because what the deputy judge does is he rejects the argument that an integrated scheme built at the same time should be one building. He goes on the question of shared access.
Yes.
If you've got a statewide service charge, for instance, as I think you did in 30 Upton Gardens, that problem is still there.
Yes, just because a development is integrated by itself does not mean it should be treated as one. The guiding principle is, are they shared appurtenances? And if so, then there becomes the question of, if they are to be treated separately,
Yeah,
how would that
you were
happen?
making points about how do you apportion service charge and so forth, but that would apply to any estate-wide service charge.
But there's a greater difficulty in that exercise if there are shared appurtenances. For example, I'm not sure if this development, there might be a shared gym. In some student developments there are, for example. And if the tenants in one block previously had access to that shared gym and they were paying for the service charges for that, if that right's suddenly taken away from them or access becomes impractical or unworkable, are they supposed to carry on maintaining the service charges for areas to which they no longer have access?
Why could that not be dealt with through an easement? I mean, there might be an easement anyway. That might be how they have use of the shared gym.
There may well be, but that in my submission, undertaking that exercise is a greater problem than treating properties with appurtenances as one. So on one hand, the court could do that, and on the other hand, it has the option of treating the scheme as one, and you avoid having to go into that issue.
Never heard of a gym being said to be an appurtenance, but perhaps it is.
It may well not be. I was using as an example because in these student developments, there are often shared areas which the students will use in conjunction with each other, and separating out the building just makes that in practice unworkable.
I think what both of your points that you made so far, what they're going to is, maybe not, but put me right if I'm wrong, that actually you're creating so much more of a difficulty, because then you'd have to set about making sure that you'd created appropriate rights in the future in order to mirror what people thought they had before, whether that is variation to these creation of easements, whatever it is. And all of that creates much more disruption and difficulty than your alternative. That's what you're saying.
Absolutely.
Yeah.
And that's the core issue which the court will need to grapple with in deciding whether it's going to uphold Carrot and let things go as they were, or create a new scheme which will require more new guidance as to in what circumstances do we treat a building which is connected, for example, as one. And that's something I develop in this case.
But you don't go so far as to say that, in fact, Carrot doesn't go far enough, because he rejected the submission that the building scheme should be treated as one building. You're not saying that he should have done that.
No, and because there are other cases which we'll come on to shortly where schemes have been treated separately, and that if one were to do that, it completely defies the purpose of Section 5.3. Where there's multiple structures, you would inevitably then end up treating them as one. So I don't go that far. In my submission, Carrot, the way that it was, strikes the appropriate balance of preserving the intention of Section 5.3 whilst dealing with the lacuna in what Section 5.3 does not address.
So you say it all depends on the facts.
Absolutely. If I can now move on to paragraph 54. So here we have reference to the Denny Tower case, in which the tenants had served a notice under Section 12, and we're in 1991 here, so prior to the enactment of Section 5.3. And the Court of Appeal decided that the premises to which Part 1 of the Act applied, and the definition in Section 1.2, by reference to a building, included appurtenances to that building, including gardens, roadways and paths, but not garages or unused land.
That was a case in which, as I remember, the landlord had not served any notices under
Yes.
Section 5. The Act is, in a sense, it's got two structural bits to it. One where the initiative is with the landlord, and the other where the initiative is with the lessees. Dean Tower was a case where the lessees took the initiative. So it was their purchase notice which defined what it was they claimed to be entitled to buy, rather than the landlord's offer notice.
Yes, that's absolutely correct. But the salient point from there is the Act envisaged scenarios where a building included its appurtenances. So to try better understand Section 5.3, one can look at another section of the Act to see in those scenarios at least, was it contemplated that the building extends to areas with appurtenances. And in my submission, it clearly does.
What if the landlord doesn't want to sell the appurtenances? Suppose he says, well, my proposed transaction is going to relate to the built envelope of Block A alone. That's it. That's all I'm going to sell. Do that, can't he?
Yes, well, theoretically he could. There's no prohibition under the Act. The requirement is to offer the tenants on the same terms as you propose to the third party.
So the landlord here could have said, well, I'm going to keep Block C to E, and I'm going to sell Block A separately.
The practical reality of that is, sorry, I misunderstood the question. So if, for example, the landlord decided to sell the buildings, the structures, but not the, for example, the car park, that would theoretically be possible, but in reality, it would never happen. Very unlikely a purchaser is going to acquire the buildings without the relevant access points and entries.
It may depend on
Yes.
particular facts, but I'm just testing your thesis by asking, well, what if the landlord decides to do something which would have the effect of splitting up what you have been calling an integrated development? So as far as I can see, there's nothing in the Act that stops the landlord from doing that if that's what he chooses to do. It may be commercially unwise.
No, there's not. And in that scenario, the landlord would have to deal with the existing rights of lessees and however he has to go about dealing with that. But this comes back to my initial submission in that there's no perfect solution to this poorly drafted Act.
Yeah.
And whatever happens, there are going to be scenarios which are either not covered by guidance or which leave some people unhappy. But what we have here and what has stood for well over 20 years now is a workable solution, and a solution which I submit that the court should uphold.
I think really what I'm putting to you is there's no irreducible minimum.
No, that's correct, yes.
I mean, the landlord could, for instance, decide to grant a lease of the roof so that somebody can build an extra flat. There's nothing to stop him from doing that. You'd be entitled, or tenants of that block would then be entitled to say, well, we'd like the lease, please.
But in that scenario, Section 5.3 wouldn't operate because he's not
Section
proposing.
5.3 wouldn't, but
Yes.
you know, the landlord is doing something which alters the character of what had been an integrated development.
Yes, that's possible. If I can now go on to paragraph 56. And this is a passage from Lord Justice Hobhouse in the Belvedere Court case. It's an important passage which I'm sure the court's read. And what one can take away from here is the Act needs to be construed and considered in light of the provisions which are substantive and those which are secondary. And the provisions which are secondary may in certain circumstances be applied in a manner which assists the enabling of substantive rights or the overarching of rights granted by the Act, so as to prevent absurdities. And what the court, in my respectful submission, will be required to do, as Sir Geoffrey Voss does at paragraph 63, is decide whether Section 5.3 is substantive or secondary.
What do you say?
It's in agreement with Sir Geoffrey Voss that it is secondary, but it's also mandatory. which creates even more difficulties. Paragraph 57, we have the K. Green case. And this case would, in fact, support to some extent the appellant's position. I'll spend some time on it because in my submission it demonstrates that even though the case is undefended, the learned judge had well in mind the competing provisions and tensions between the various parts of the Act. And what the court found in the K. Green case was tenants of premises that had served a purchase notice, each of the 3 buildings had to be considered separately.
And that was despite the fact that the Act didn't require that at the time, is that right?
Yes. At least for the purpose of 5.3.
I was in the case, but I have no memory of it.
Yes, that's my understanding. So
that's the court inventing that, getting it from somewhere else in the Act. The requisite majority, is that how they got to that?
yes, there's some.
So the quotation from Lord Justice Aldous refers to section 5.5, having to sever each building from the others, which seems to suggest that what we now have in 5.3 was previously in 5.5. Is that right, or am I misinterpreting that?
Well, I can double check, but I had a look at the Act as it was initially enacted, and there was no reference in section 5 to severance. Whether between its initial enactment and 1996 the provision was inserted, I'm not too sure. But we do get some assistance from the judgment of Lord Justice Stoughton at the bottom of the page.
He also refers to it. He also says, in doing so, to sever the transaction as required by subsection 5. So it does look as though there was a provision in the Act as enacted which required the transaction to be severed.
My part, at least, it would be helpful if between you could provide a copy of section 5.5, the Act as it was at the time of these authorities.
Yes.
Thank you.
But yes, in any event, K. Green would seem to go against my submissions today, and the learned judge in Carrot recognised that. And what he goes on to say is, although the decision may go against some of the reasoning, it doesn't go against the ratio of the case.
What does Mr. Voss identify as the ratio? 60, is it? Section 12 notice can be valid even if it does not deal with each building separately.
Yes.
That's because the court decided that the requirement in section 12 was directory.
Yes. That's in the passage above, yes. So it is a directory rather than a mandatory requirement. So therefore, even if there wasn't strict compliance, it didn't invalidate the notices that had been served. whereas in section 5.3, although they are somewhat awkwardly described by the learned judge as secondary, they are also mandatory. And the key distinction with K. Green as well was the structures in that case were separate in a meaningful sense.
I think some of them shared facilities.
They did. And this is dealt with in paragraph 67. I skipped a couple of paragraphs there, but if I can come back to paragraph 63, if I may. So here we have the learned judge's conclusion that the section 5 is secondary rather than substantive, and that they are part of the machinery of the legislation. He also recognizes, however, that given their mandatory nature, they cannot simply be disregarded. At paragraph 65, he rightly recognizes that there is a tension within the Act, and that on a strict reading, each building must be dealt with separately. However, as I set out at the outset, it's common ground. The court has to depart from the strict wording of section 5.3, whatever construction it approves. What the learned judge then goes on to do at paragraph 66, and rightfully in my submission, is to say that in order to achieve the aims of the Act, Parliament must have intended to create a workable procedure. In my submission, the difficulties both councils are faced today as to the exact scenarios and circumstances are encapsulated perfectly by that point. There needs to be a workable procedure which landlords and tenants can adopt, and in my submission, the decision in Carrot provides that. Anything which goes beyond Carrot or doesn't go as far in my submission would just create further uncertainty and greater mischief, and the decision therefore creates the right balance in a very difficult situation. Going on then to paragraph 68, and here the learned judge attempts to discern the intention behind the inaction of section 5.3, which was to prevent landlords from amalgamating numerous structures to hinder qualifying tenants in achieving the necessary majority. And in my submission, that is correct. An unscrupulous landlord, not in this scenario.
But why? I mean, I'm not suggesting he's necessarily wrong, but on the other hand, your submission is he's getting that purpose from the wording of the legislation, when section 5.3 itself says absolutely nothing about qualifying majorities. So that's his divination of the purpose, and maybe he's right, maybe I don't know. But you don't get that out of the language of the subsection itself.
In my submission, if you look at the introductory text and applying that, one can come to that conclusion.
Can I contrast that with what Mr. Justice Zaccarelli said in York House? He said, paragraph 98, of greater relevance are the expressions of the purpose of the Act in Belvedere and Dean Tower, namely to give leaseholders of residential flats in a block of flats improved rights to control the upkeep and maintenance of the block as a whole, not the integrated development.
So, that's one of the.
And that's one of the points that Rudetsky and Clark criticise the Carrot, that it makes cooperation between leaseholders of blocks more difficult.
It does, but if I can perhaps look at the introductory text, which is page 3 of the authorities manual. So the Act has more than one purpose, primary purpose. One of them, and the first stated, is an act to confer on tenants of flats rights with respect to the acquisition by them of their landlord's reversion. So it's not limited just to necessarily individual buildings. And then it goes to make provision for other matters, including service charges, variation of long leases, and so on.
Can I come back to 68, which you were addressing? Because the other question I wanted to ask about this is that when he's looking at the purpose, he talks about preventing landlords amalgamating separate structures or buildings. And it might be said that that's blurring the question, because his very phraseology is failing to distinguish between structures and buildings. Whereas Mr. Duval's submission is, well, you need to start with how do you define a building? And his submission is, well, ordinarily, subject to his proviso, it's a structure.
Yes, but he deals with paragraph 4 of his judgment, and that he uses the term structure to mean a single integrated structure separated from another structure. But yes,
Paragraph 4.
Yes. So my lord is quite right. Paragraph 68, he doesn't differentiate between the terms structure or building. And it may be that a structure is a building, or it may not be the case. It's just fact specific.
Right.
Whatever difficulty in my submission we have with discerning the intention of section 5.3, the important point of paragraph 68 is the last sentence, in that what Parliament cannot be taken to have intended is that the common yards, gardens, and other pertinent areas should have to be split into one or even several parts in order to satisfy section 5.3, and such a result would be absurd. So if the court is satisfied with that part of the judgment, then in my submission, the decision is correct. If Parliament did not intend common yards, gardens, and other appurtenances to be split, then this is the construction which Parliament intended, even though it did not expressly set that out in section 5.3.
How does that fit with your acceptance, as I thought, that the landlord could have decided to sell block A alone
because that then section 5.3 is not engaged at all. So we're in a completely different paradigm in that scenario. If there's not more than one building or one structure being disposed of, then this whole issue doesn't come into play. So it would be a different test.
But if the landlord could have sold block A on its own, and that wouldn't fall foul of section 5.3, how does it matter if the landlord has decided to sell B, C and E as well?
It matters because that otherwise section 5.3 is not engaged. It's whatever the purpose behind section 5.3 might be, if it's not what's set out. If you are not dealing with separate buildings, you simply don't come into that scenario. So
What if the landlord had decided to sell block B alone? Or rather, no, blocks B, C and E. Suppose he decided to do that, keep block A.
well, in this case, he would have added difficulty in that the leaseholders in block A have demised to them the car parking spaces in front of block C, but parking that to the side.
Why should that stop the landlord from selling the reversion to those demised spaces, if that's what he chooses to do?
Because then the part of what he's selling would be belonging to block A. So he can't sell, he would have to somehow deal with block A's rights over their car parking spaces, if at all.
But why? If he follows the line of the demise, what's the problem?
Well, in theory, there may not be one, but and it's a complicated situation, to which I really don't have a great answer, if I'm being honest. But
What Mr. Voss seems to be saying in paragraph 68 is that there is an irreducible minimum. And that's where I don't see where he gets that from, given that the Act applies even when the landlord wants to make relevant disposal in relation to part of the building. Or one structure out of several around a shared facility.
the major issue, the Act simply doesn't deal with all of these scenarios. There's no mechanism within the Act for deciding if something is to be split up, how that's to be done.
Yeah.
And that's the issue. And in order to deal with that problem, Sir Geoffrey Voss comes up with his solution, which may be imperfect.
Is his solution that you can't divide it up, or is his solution you don't need to divide it up? On the facts of the case, the landlord hadn't divided it up. And what the judge is saying is, well, you can't compel the landlord to divide it up in this way. That would be unworkable. But what if the landlord chose to divide it up? Is that prevented?
I submit the landlord can't choose what to do. He has to do what's mandated by Section 5.3. But
yes, as you say, that Section 5.3 doesn't tell him how to settle the transaction, except that it's got to be building by building.
If we assume, for example, that the dividing it up was a relatively straightforward exercise for whatever reason, in that scenario, in my submission, it would depend as to the ease with which something could be divided up. That's the only workable solution I can come up with. There may be scenarios where dividing up is very limited and very easy to achieve. There may be other scenarios, such as this case, where it's overly complex. But again, I would submit it's a matter of fact and degree, case specific on an individual case-by-case basis. There cannot be one formula with one size which fits all. If I made a paragraph 72, the learned judge amplifies his reasoning from paragraph 68. And he says, in the absence of a provision which explains how difficulties associated with severing can be resolved, that's what leads him to think Parliament must have intended in a way for the Act to be construed to render such a provision unnecessary. And if one ties that back to the presumption against absurdity, as I set out at the outset, if Parliament had intended properties with shared appurtenances to be split into unwieldy parts, then it would have required express wording to that effect, giving a procedure to split them up when it's simply not there.
In the sense that if that were the case, you're saying there would be some more subsections which said, when you're severing the transaction, you shall create a reciprocal mirrored easements,
Yes.
etc., etc.
Yes, and give some sort of process to follow for doing that. The reality is, most likely, the draft is simply overlooked.
But if
dealing with any of
if
these
the
scenarios.
tenants have easements to use these shared facilities, why are they affected by the change in the reversionary? Easements will bind the reversionary. And if they don't have easements, what right have they got anyway?
Dealing with each in turn, if they do have easements, in that scenario, the difficulty would be splitting up may give practical problems to the exercise of the rights of those easements. For example, in this scenario, if Block A and Blocks B, C, and E were treated separately, how would one arrange access to the common shared parts? If, for example, the new freeholder of Block E decides to put up a fence in the middle, separating out his property
Committing a
from the...
nuisance by interfering with a legal easement granted to a lessee.
And that's the problem which will be created if that's done, and exactly what the learned judge was trying to avoid. So we do come back to the discussion we had earlier on, in that one solution may well be to do that and to deal with all the consequences that flow from splitting the properties up and dealing with easements, rights, new leases, and so on. That is one option. And what the court needs to decide, in my submission, is that the better solution versus what we already have?
I still haven't quite understood why any new easements need to be created. Either the lessees have the right to use the shared facilities, the legal right, or they don't. And if they do, the legal right, at the moment as I see it, will continue to be enforceable against the new landlord as it was against the old. And if there is no legal right to use the shared facilities, why should the lessees acquire one?
The answer to that may well be found in the next paragraph, the last line, which is that the Act cannot be construed to allow qualifying tenants in two separate structures to each acquire by separate transactions the same gardens, yard, and outhouses that they had up to that time using in common.
Sorry, which paragraph are you on?
73.
73.
The last sentence.
Yes, but that's acquiring the ground, not the easements.
But in my submission, the same argument would go for if there was a shared easement. If two tenants, let's say for example in block A and block C, had access over the same area, then how does that work in practice? Would they be required to use two separate notices to both acquire the same piece of the same easement, the same rights? And my final submission, if I may, on Carrot is at paragraph 74. And it's this guidance which I submit the court should approve and uphold. If I may now move on to the second part of my submissions, which is dealing with the judgment of His Honour Judge Hodge, which I can do fairly swiftly. If the decision in Carrot is upheld, on that assumption, I submit the judge gave a very carefully reasoned judgment. He addressed all relevant matters which support both the appellant and the respondent. He even went so far as to raise arguments and consider them when they had not been advanced by the appellant. Paragraph 82 of his judgment.
So 82?
Yes.
Yes.
He sets out the various competing factors, whether they point to one or more buildings. And then applying all of those factors, he reaches his conclusion at
I
paragraph.
was thinking that something's gone wrong if you've got to consider 13 separate factors to decide how many buildings you're looking at. Now, I'm not saying that's wrong with the judgment, it may be wrong with the act, but it seems odd. You've got all these factors to consider when the question is how many buildings are there.
Yes, well, it may well be that His Honour Judge Hodge done too good a job and went into too much detail, but yes, the first point is that these factors only come into play if there are shared appurtenances. And if there are shared appurtenances, at some stage, somebody is going to have to think about all of these issues. And it's only right that the court does so when it's reaching its conclusion.
Can I take slightly out of order? You refer to appurtenances and they were referred to also in paragraph 73 or 74 of the Carrot judgment. How do appurtenances fit in to section 5.3?
Do I understand my lady's question to be what amounts to an appurtenance, or
What relevance does an appurtenance have when you're doing the severing in section 5.3, and how do I know that it does?
well, if there are appurtenances which are enjoyed by tenants in more than one building, then the guidance is set out in Carrot would come into play. If there are not any appurtenances which are shared between the respective buildings, then what the landlord just carries on and deals with the express wording of the Act as it is. There has to be,
And the pertinence becomes relevant
because of all the greater issues which would arise if they had access rights and so on have to be split up.
You keep saying this, access rights have to be set up, but either they are there or they're not. Why do they have to be set up?
Split up, sorry.
Split up,
Split up,
sorry.
yes.
Why do they have to be split up? If I have a right to, if I'm a unit holder in Block A and I've got a right to park a car, or I'm demised a car parking space outside Block B, I've got a right to use it. Why do you need to split anything? Any more than the tenants in Dean Tower who had their leases of garage would have lost that right on a transfer of the reversion. Just wouldn't.
In Dean Tower, I understand the garages were let under a separate lease, which is why they didn't form part of the.
Does that matter?
It's not an appurtenance if it's leased separately. So in my submission, it would.
This is a convenient point to ask you about what the judge says in paragraph 83, which Mr. Duval criticised, because it's the sentence in the middle of that paragraph. In the present case, factor of magnetic attraction seems to me to be the shared use of back Bow Street as the only means of access to the car parking spaces, etc. But why, if it's a public highway? Why does that convert separate buildings into one building?
Perhaps I can answer that question by reference to the visual impressions. So on page page 470 of the supplementary bundle.
Sorry, I missed the reference. 470.
70. Yes.
Is that volume 2, is that?
Yes. Actually, so perhaps we can work from 4, 6, and 9, please, because the relevant blocks are marked.
Yes.
So there is no access from Ebo Lane on the right side to Block C. So access must come from back Bow Street. And what I understand the judge to be saying there is, if the 4 buildings are treated separately, or was more than one, how does one deal with the issue of access to Block C going over and past Block A? And of course, we, as the appellate court, we do not have all the evidence that was before the learned judge. There were some plans which showed there were ramps and so on in front of Block A and E, which would complicate access in dividing up and splitting those ramps.
Just explain that to me again. You were saying, yeah, start again, I'm sorry.
So if, for example, if you go to page 471,
Yes.
here you can clearly see where Block C is marked. The car parking space is in front of Block C.
Yes.
It should be common ground. It's one of these which are demised to Block A. And what I understand the learned judge to be saying is, if the only means of access is via back Bow Street from Block A, or between Block A and Block E, how would one divide up the relevant buildings if they are treated separately?
I'm not sure I follow what the problem is. So in terms of access, it's a public highway, so there's no problem of access. In terms of division, why not just follow the line of the demise?
the I believe the issue of the access isn't via the public highway. It's how do you split up the access between Block A and Block E? Where would the line go?
I'm not sure I'm following that. What's the problem with this public highway?
No, so no, the public highway isn't in the space in between Block A and Block E.
It is.
Where is it then?
Sorry, perhaps maybe I misspoke earlier. If you look at the plan on page 470, it's Fox Street on the left-hand side going into Backbow Street. That's the public highway. As soon as you enter into, as soon as you turn right off Fox Street, going into Block A, that is not a public highway.
So where is Backbow Street? I've misunderstood.
Backbow Street, my understanding is it's just before you enter the start of Block A and E.
Well, if we look at 470, Backbow Street is marked, and there's the street between the two. Now, if what you're telling us is that you were wrong earlier and it's not a public highway, then I can understand the point.
Yes, maybe so. Whether or not Backbow Street is going into the development, the space from between Block A and Block E is not a public highway, but that's a private land.
Why do you need to divide it at all?
The new owners of the respective blocks may well.
Sorry?
The new owners of the blocks may well wish to divide up their respective block from the rest of the development for various reasons.
Well, as long as they don't put up physical barriers which would interfere with tenants' rights of access, why shouldn't they?
It's possible, yes. I'd have to consider it could be possible to split it up without barriers.
But you'd have a situation in which one block was responsible for maintaining the access way to the midline, and the other half.
Yes, and this court is will be more than familiar with boundary disputes, neighbour disputes. If that were to happen, there can be all sorts of issues arising between who's responsible for what. And just on this point, however, it's important to bear in mind that the conclusion that the judge reached, it certainly was one which was open to him on the evidence. He had the benefit of seeing and hearing detailed evidence. It's not suggested, and in my submission it cannot be, that the findings are perverse in that they were not open to him to make. If the decision in Carrot is upheld and the guidance taken from there is said to be proper guidance, he clearly has reached a decision open to him on the evidence, applying that guidance. And for that reason, this appeal should fail.
As a matter of interest, did the judge have a site visit?
No. And the other issue in splitting up, or perhaps which is I've raised maybe not so clearly, is there's an inconceivable amount of scenarios which can arise. One scenario which did arise in this case was issues with the electricity and in the improvement notices. And if the plant, electricity, or other services were required to be split up, that would, in practice and in reality, cause a lot of difficulties for the respective tenants. You may well foresee a situation where they blame each other, in that one part says it's your fault, you haven't done what you were supposed to do, and the other blames each other. So, bearing in mind the whole, in my submission, his decision was the right decision. And at paragraph 62, he sets out the various factors from the respondent's evidence which support there being one building. I don't intend to go through it in detail, but I would ask the court to note it in particular.
Yeah.
Yeah, if we look at the second item in that list, it says public access to block B is via Back Bow Street, which runs between blocks A and E, which does tend to suggest that it is a public highway.
My submission on that piece of the evidence was that if members of the public are intending to access, it's a word used colloquially to mean individuals or other members of the public, such as, for example, the rubbish collection agents and so on. It's more so a reference to the persons being public rather than Back Bow Street being a public highway. I may well be wrong. This wasn't an issue from what I recollect. It being a public highway, it wasn't something which was canvassed at the trial. My understanding, however, the parties proceeded on the assumption that it was not a public highway. But in any event, that perfectly gives an example of the dangers of this court attempting to look into the factual findings and make its own. The judge saw the evidence. He had the benefit of detailed cross-examination. If that was a point which the appellant wanted to take, it should have, and it would have been recorded in the judgment. My lords and my lady, those are my submissions on the appeal, unless there are any further questions. I do have some short submissions on the respondent's notice, if I may. The respondent's ground 1 is pursued on the basis if Carrot was correctly decided. It's self-explanatory. It's not conclusive, but it gives further weight to the conclusion of the judge at paragraph 82, subparagraph 13, in that there was one enforcement notice, electricity improvement notice, served in respect of all the blocks. So they all were required to cooperate together to ensure compliance with that notice. And if the blocks had been separated out, that would be that much more difficult. I don't intend to say anything further on that. I have set out detailed arguments in the skeleton argument.
Can you just remind me in relation to that? Is this improvement notices post
Yes.
judgment?
Yes. So there was improvement notices previously, which are referenced in the judgment, but there was further electricity improvement notice, and that can be found.
So do all the blocks in question share electrical services? I thought we were being told that A and B, C and E and other separate services.
Well, Doug mentioned it was single notice for all 4 blocks in 2213.
So yes, I understand block A and blocks B, C and E shares different plant room, but on page 58 is this notice of the core bundle.
58 of the core bundle.
Yes. This is post judgment. So this isn't a copy of the actual notice. It's a summary of it from the letting agent.
Which page are you on?
58.
58.
Yes, this is an email from Dave Blackman, the student letting agent, and he says, "We are writing to provide an urgent update regarding the ongoing electrical supply issues at Fox Street, which could have serious financial and operational consequences for all blocks if not resolved. And a critical risk to all blocks. Scottish Power disconnected the supply to Block B due to illegal fusing and refused to carry out repairs. As a result, there was an emergency prohibition order rendering all flats in Block B uninhabitable. And then at the bottom, they say Scottish Power have confirmed that unless a fully compliant and legal power supply is installed, they will disconnect all blocks A, B, C, and E." And what this demonstrates that in practice, whatever may theoretically be possible, there needs to be cooperation between all the relevant tenants and the buildings, at least in this development. So moving on to the respondent's ground 2, which I can again deal with fairly swiftly. If Carrot is wrongly decided and a building cannot be more than one physical structure, then blocks B, C, and E cannot be one building. Block B is physically separate from block C and E. And at the least, block B and C and E must be at least 2 buildings. There's a question mark over block C and E. They do share a connection at some level. And if one were to apply section 5.3 strictly as it appears, and I would be bound to accept the respondent would lose on block A. It is a separate building. However, one notice for blocks B, C, and E was unlawful. It had to be 1, maybe 2 or 3 separate notices.
What's the consequence of that outcome on your section 12B notice?
The end.
Entitled to apply block A or not?
No. So in this scenario, the respondent would not be entitled to block A, but they would be entitled to compel the sale of blocks B, C, and E if they so chose to.
Does the fact that the Section 12B notice refers to the whole of the development, meaning that it's valid or invalid.
Well, as we saw, I believe in the Belvedere case, those Section 12 is directory rather than mandatory, and we had the similar scenario in that the Section 12 notice deficiencies were caused by the landlord's failure in the first place. So if the landlord got it wrong, in my submission, the court would either construe the Section 12 notice appropriately, or permit the tenants to submit further notices in light of the developments. But it would be a tricky, if we get to that. I don't submit it's something which this court can resolve. What would be required would be guidance as to the correct approach, and then remitting the matter back for a fresh trial on whether blocks B, C, and E are 2 or 3 buildings. My lords and my lady, unless you have any further questions, those are my submissions.
Thank you very much. Ms. Shakir, do you want to add anything?
My lords and my lady, no, thank you.
Mr. Dwyer, do you want to reply?
One thing in reply, and a couple of practical points. The point in reply is there was some discussion about paragraph 68 of the Carrot judgment and the intentions of the legislature. Your lordships and your ladyship may have picked up from our skeleton that Mr. Cordova researched Hansard and couldn't find anything there in Hansard. Ms. Cordova has done some research on Westlaw while my learned friend was making his submissions, and it appears that Section 5 in its original form had a subsection, Section 5.5, which was identical to Section 5.3. We'll print out and obtain a copy and email it to your clerks later this afternoon.
Yes.
And we'll also research the point about whether Backbow Street is a public highway or not. And we'll find the answers to that. Again, we'll be able to find out this afternoon. That's all I have to say.
Right, well, Carrot has stood for 20 years or 30 years, it's now been challenged. It's up to us to decide whether the challenge is well-founded or not. So we will go away and think about it. You will get a draft judgment or judgments in due course. They will be sent electronically under cover of an embargo, which means what it says. So they can only be distributed to those on the list which the court has already got. It will be your opportunity to correct our English but not our reasoning, not to introduce new points. We would hope that in the light of the draft judgments you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions and we will make the form of order we consider to be appropriate. The eventual hands down will itself be electronic by email distribution to those to council and by release to the National Archives.
Thank you.
Thank you very much.
Court rise for 8 more.